Today. And go back to the. They uploaded it. Information.
Did you see it?
That's some fear. Just bought a store.
Yeah. All right, at 6 o'clock, I'll call the meeting to order and we'll start by saying the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, indivisible, with liberty and justice. Thank you for being here. We do have some adjustments to our agenda. We will address the English Town Road issue first, since the town's attorney is here and lots of people are interested in hearing about that, talking about that. Do any select board members have conflicts of interest tonight? We have, I think, 3 sets of minutes.
I think it's 4 actually, but we can go through them.
Right. I wrote down the special town meeting at which we approved the comprehensive plan from October 20th,
Right.
the November 3rd select board meeting, and the November 10th special select board meeting from last week.
And also the 20th, the regular select board meeting from October 20th.
Okay, regular meeting that was after the special meeting. Did people have a chance to review all of those? Did anybody have any changes other than what we've already gotten to Judy?
No. Excellent job, Judy.
Thank you.
Well, somebody's on the
I make a motion, we approve all of those minutes.
Second.
All in favor? That's all of us. All right, communications that the select board members and the town manager have received. Obviously, given the issues at the school, we've all received a lot of communications. And I think unless something requires action or somebody wants to say something about any of those, we can just share that we've had many communications from interested citizens. Did anybody want to say anything?
I just want to note that if people are receiving emails that are threatening in nature, there's anti-threatening laws about elected officials. So depending on what it says, it may be a sheriff's matter.
I did have one particularly vile email that I sent to Brandon just to all right, so
I've received several letters of support for the proposed coffee shop at the old Cod End building. So I think there just seems to be a lot of community interest in seeing that project happen. So that will be going before the planning board.
And what they're proposing is a seasonal coffee shop. Obviously, the wind blows through there. I don't know how it would work otherwise.
And yeah, I think a coffee shop and an event space. I believe that they're reviewing it tomorrow. Is it
Next week.
No, it's next
week.
Tuesday.
I got thrown off. So it should be on that agenda. So if folks are interested, just wanted it on their radar. And then we received a letter from the whole board, correct? From Josiah.
Yes.
That
I thought we could talk about that in the harbor committee section, since it might require follow-up by
Great.
them. But don't let me forget, Brian. All right, the warrant. I printed it out, but I didn't bring it to anybody. Do you have And Irene, did people have questions about the warrant that Irene circulated today?
I looked it over, it was okay to me. But what do I do? Was there anything unusual in there, Irene? Didn't look like it.
No.
No.
All right, then, is it our consensus that we will authorize the expenditure of the $160,387.38? Yes, all right, then we can sign this for you. Are there any public comments about things that are not on tonight's agenda? Anything anybody wants to say about something else? No, all right then. Bill Kelly is our town attorney, and we're gonna have you come up and sit next to Brandon here. Scooch down a little bit. So that you can see everybody and everybody can see and hear you. And I don't know if you and Brandon have talked about background or explaining where we are.
At this point, every abutter to English Town Road received the memorandum that Bill had shared with the select board, as well as the sort of supporting historical documents that inform the 130-year history. And so the long story short, essentially, and I'll let Bill get more into the specifics, is that the status of the road is unclear. And because of several different steps along the way. And so we wanted to invite Bill here tonight so that if abutters had thoughts, questions, concerns, it took some of us, weeks to fully understand the full picture. And so getting the packet with the memorandum that outlines it, as well as the history of it, can be a lot. And so wanting to provide space for abutters to understand it more and share their thoughts. Anything you want to add at this point?
Hello, everybody. I think you probably have a sense, if you haven't seen the memo that Brandon's talking about, the copies of it up here, along with copies of warrant articles, as well as an original layout and taking of the road back in the 1880s. Roads are tough in Maine, and when you have a period of time during which there's no town maintenance of it, and I understand there's a section of this road that hasn't been maintained for quite some time. Roads can come into being because of public use, and they can go out of being because of lack of use and lack of maintenance. And I tried to address some of those concepts in my memo. What that means, I think, for tonight's purposes is there are no simple answers to the status of the portion of the Englishtown Road that has not been maintained by the town for decades. And it's best to see if there can be a way to work that out among private property owners if possible. I have road cases, I've had road cases over the years. I've got one pending now in Superior Court in Waldo County. They tend to be complex, detail-oriented cases that require a lot of memory, a lot of, and unfortunately, memories only go back so far in terms of uses. Town documents and records, which in this case are frankly a little bit at cross purposes and confusing. It's what they really meant at the time they were enacted. And it can make for a really uncertain result in court. Doesn't mean the town can't ask the court to declare what's going on with the road and ask the butters to, or even involve each abutter as part of a lawsuit. There's so much uncertainty with that process, though. I think it behooves you, if you can, to come to terms that work for individual property owners as well as the town through the select board. You might as well make up something that works as opposed to going to court and find out something that doesn't. So that's sort of a general overview. There's a lot of detail in these documents. I'm happy to answer questions, or if perhaps some folks who were referenced in the letter, which created the immediate issue for me to look at it, have come to some kind of terms or outline. I'm not sure what the status of that is. Happy to hear about that. I'm happy to comment on that as well. So that's sort of some general thoughts, and I'm in a way, I'm here as a resource. Not necessarily the shall answer man or whatever that commercial is with the it's the hotel where, I have the answer because I stayed in a Motel 8 last night or something. There's enough uncertainty here that I'm happy to have anybody provide an alternative legal opinion and look at that. As this is not a perfect science. So I'll stop there and answer or get directed as anybody would wish me to be.
Well, and I think one of the important points is that if there isn't a resolution that's possible with the property owners, a voluntary resolution between the town and property owners, what Bill is saying is you can go to a court and say, here's all the evidence, tell us what the law is about this road. But obviously that would cost a fair amount of money to the taxpayers and anybody else who was a party that wanted a particular thing from the court. And then we don't have control over how it comes out because it'll be what a judge decides. So, if it's possible to reach a resolution without spending a lot of money on lawyers and waiting a long time, I assume, before a judge would decide. That is the reason we invited the abutters to come and share your thoughts and wishes and questions with Bill.
Let me actually just follow up on that comment because it's quite germane to the case I have in Waldo County right now. It was a case about a road. Several of the abutters sought what's called a declaratory judgment. They sued the town, and then there were 15 other abutters who are now what are called parties in interest. That case was in court for 16 months before the judge said, we're going to restart. And he asked the plaintiffs to restart their complaint, refile their complaint after 16 months. And so that was just straight delay. The other problem is these cases tend to be at the bottom of the court's list in terms of when they're actually going to get acted upon. You can tell by just what I just said. So it would be years before there'd be a determination in the Superior Court if it was necessary to have the court issue a decision. So it's not a small matter and that the courts are backed up and these are not priority cases. No, that's the bad news. More bad news.
Yes, Elaine.
Are you able to like give me like a bird's eye view of what actually is being proposed or what the legal, like, what is the dispute? Or what are the two sides? Like what's, I got the letter, but I don't know what's.
Okay, well, you should know part of the story, because it was my family property. And I lost half of it in my divorce. And this is my ex-husband harassing me once again over my property. But the last person to use that road, my great uncle took his old truck to Long Cove to go fishing. And when when Zell has improved the road, we used the road bed that's always been there. The right of way goes a little off to the left and through Theron's garden. And we didn't want to upset him. So we didn't put the road through his garden. We put it on the original road bed, trying to not upset him. But it still happened because I'm doing something with my property out there and he can't handle it, basically. And the road is in, looks beautiful. A lot of people are gonna be living out there eventually, which will mean tax revenue. And that's it.
Was
If
Yeah,
I
Sal.
might just add, just some more history for neighbors. Dan and I we began looking at the property in February of 24.
when we met Carolyn, and I knew she had an interest in selling property. We, through our due diligence period before we purchased the property, we reached out to the road commissioner and town manager at the point, Rick Erb, and we had a discussion about what the process would be if we wanted to make improvements to an existing town right of way of a road, including adding electrical service. Those were the two, and it was discussed at that point. Rick said that the process is, as road commissioner, we submit our proposal to Rick, and we outlined exactly what we were looking for. He, as road commissioner, reviews it with the select board, and they make a determination. And we submitted a very thorough letter. I have a copy if anyone wants to see it, but it definitely identified an existing, there's this existing path that we were improving. I think was an important distinction, and it came to the select board in May of 24, and the minutes are available, but I think essentially it was discussed and perhaps it wasn't fully followed up upon. When Mr. Erb retired at the end of June, Dan and I were still in our due diligence period for the property. We didn't, this is a big investment for us. We didn't feel comfortable moving forward with the sale without formal approval from the town of St. George. And so prior to Rick's retirement in June 23rd of 24, he sent us a formal letter on the St. George letterhead that said we have full permission to improve the road and add utility poles, but made it clear the town would not maintain anything past the maintained line. And as part of our sale, Carolyn paid for the full survey. There's a full Gartland-Dorsky survey that investigated that, put together a survey and determined this line at the edge of the town maintained. And so with that letter and our lawyer's blessing, we went forward with the sale of the property with the understanding that that was the town's review process and that we had completed the review process. Only upon approval of that letter did we purchase the property. And ever since then, we have been saving to pay for the improvements to the road so we can continue with construction on the property. The road improvements were completed by Justin Long in August of this year. Prior to us doing the improvements, we did reach out to the current town manager and say, we're about to make a big investment in improving this existing road, and we asked if there were any concerns we should be aware of. When we got the approval to move forward, we had the road put in. A couple days, I think, following the road place improvements happening, we did get a correspondence from the town manager questioning the previous town manager's right to give us that approval for the road. As you can imagine, we were a little shocked through that process because it was a couple days too late to undo that. And so since that time, I'd say in early September, the select board has had 3 executive sessions when they have discussed this matter. And I think the reason they're calling us all here today is they hope that we will negotiate an easement with Thurin Benner, who's a man we've gotten to know in our neighborhood, who has been open to negotiating an easement after some back and forth. And so, I mean, at least that's my perspective of why we're here today. I think that there are some questions that have come out, and I think Bill's letter identifies that. But I guess even Dan and I wonder, like, what are we really doing here today? But I don't want to speak for you.
Yeah, I couldn't identify in your history of the road exactly where someone that was a property abutter wouldn't have the rights to access their property via the road or bring in power. It seemed like the property abutters never. So maybe you could point that out, like where, the difference between a public right of way, that's for anyone, but then there is a road and abutting property owners presumably never lost the right to access their property. So why would we need to leave for that?
Well, I think part of the purpose of the letter was to talk about this bridle path concept.
Mhm.
And what did that mean in the original taking back in 1889? Because it was a little confusing. Private landowners asked for one thing, the select board referenced a second thing, and then they certified a third thing. And I understood there was some discussion, I'm not sure who from in town abutting the road, that if it's a bridle path, then there's no right to put vehicular traffic over it. So we have to start, if we're gonna look at this in a legalistic way, or at least a legal rights way, what actually was taken back in 1889, because at that time, damages would have been paid for a particular type of use. And
It seemed like they were $25 were paid.
right.
Okay.
And then the question is, what was that $25 paying for? What were the rights that were established? So the first unfortunate part of this is the certification from the select board back in 1889 said a bridle road. And I gave you some commentary about what a bridle road or a bridle path is,
Which was codified after.
which was after.
Right, so that word wouldn't have meant what
I don't know that.
Okay,
That's part of what we'd use that as sort of a benchmark that 30 or 40 years later, were they codifying what towns thought that meant in 1889? I don't know the answer to that
sure.
and couldn't find a whole lot of help.
But people did drive vehicles on the road.
Yes.
It's been used quite a bit.
Yeah, and that's one of the parts of when you do road cases. What does that mean? And what it means, for example, is let's take a hypothetical. Not so hypothetical, but let's take an interpretation. In 1889, the only thing that was taken was a bridle path, bridle road. Now, they didn't have cars then. But was it taken for what we call highway purposes? And that's sort of a magic phrase. And it's in the case law and it's also in statutes. And highway purposes meant basically public conveyance of whatever, horse and buggy at that time, or carts or whatever people were hauling around. And then fast forward to the days with cars.
Now, is there a difference in that between someone that owns property on the or doesn't have?
No,
Sounds like it's on the landmark. Same thing he tried to do in court.
But if it was a bridle path, the bridle path started at my Uncle Peter's driveway. So all the houses on there are illegal. Because the bridle path started at Pete's driveway.
well, I don't know, but I think if I could just turn back for a second, because your question is a core one. And then there was a question about what happens because people did drive on it. So bear with me for a second, because I'm not making this stuff up. It's how it would be analyzed, and it's part of the complication of the case, which is both to your benefit and maybe not to your benefit. And that's the uncertainty that we're talking about. So just bear with me for a second. So damages were paid. What were they paid for? Let's assume that it was a bridle path that was not like a public highway. It wasn't for all purposes of conveyance of whatever livery the public may have used over that section of road. So that wasn't paid for. Those were not rights that burdened property where this road was laid out. It was only laid out as a bridle path and therefore basically a horse trail, pleasure horse trail of some sort. But somebody just said, well, cars have been going over it. And they went over it for years. And that's where these concepts of roads can come into being, public rights in roads, and they can go away. They can go away because of what's called abandonment, which is lack of use or lack of maintenance for a 30-year period, straight 30-year period. lack of maintenance by the town. Or they can come into being because people start driving on it, and therefore they drove on it long enough, it must be a public easement now. And if that's part of the fact pattern here, and I don't have all the details, because you all know a lot more about the road than I do, then it could be that such rights came into being over time. But I can't tell you that that's the case, sitting here. What I find in these cases is people have very different perspectives. Oh, no, that wasn't the public going over the road. That was just the abutter who was going to their house.
But again,
They
so
built a bridge out there also.
Okay.
Why would they do that if it was meant back in the 1800s? I don't believe they went out there with cement and went down across that wet spot so you can drive down that. It's been used for quite a while
Who built,
as a road.
who built the
I
bridge
don't
and
know.
when?
It was way before I came into the area, but there is a road, goes right down through and there's a little bridge that crosses it. You go far enough down, just before you get onto, what's that?
Palace property.
Okay, so another fact of who
So
did
it's
that
been
and when.
used for quite a while by the looks of
Yeah.
that cement bridge as a road. Not a bridle path. Bridle path, I understand, they turn into dirt roads, which turn into highways if there's enough people demanding it.
Yeah.
These families wanna move in and improve the road like they did from the original.
Maybe we could go back to the town meeting that Billy Johnson. When he put his house out. Because I know Peter challenged it. And the town made a ruling so Billy could put a road out through there. And he was
that
the one who
1996? Do we know?
building the road.
Yeah,
That was a long time ago.
was that in 96?
No,
Was it the 2009?
no, it was older than that. I moved here in 92 and it was a little before then.
Oh, there's one in 1975. One action was taken in 1975, right?
To discontinue maintenance,
Or something like that.
and then with the
Because he
amended,
put it in himself to take care of it.
and then with the amended restriction, amended on the floor, restriction of horses, bicycles, and pedestrians.
So the things that you folks are talking about in terms of like the history of the road and the uses and the improvements and who did it and who used it are all important things to gather. And will definitely inform both the select board and you all more. But I can't sit here and tell you, because I don't know the history, what the answer is, but they're all parts of the puzzle. And how long they went on for is important, and who used it is important. Because, for example, to create public rights sufficient for vehicular traffic typically has to be used by what they call the undifferentiated public, meaning Joe Q public was going over there to get someplace else. They weren't just going up the road to get to their house.
I think you keep talking about public traffic, and I think that there is a distinction between public traffic and abutting property owner.
There is, absolutely.
And I think that we are abutting property owners. And so that's what the letter from Herb said. It said the Maine state law says abutting property owners are allowed to improve the road that they live on,
If there's a public easement.
which you couldn't take away because it wasn't cleared after 1965.
Because, well, as my letter says, I don't know what's there legally.
Right.
But yes, it is true that those who are trying to get to their home over a public easement, if the town doesn't maintain it, you're not wrong. Then the private landowner has the right to improve it to get then sufficiently to get to their house. But first you have to have a public easement. It's not just any set of rights. And I don't know what you have.
And just, I didn't want to interrupt when you were talking, Zell, but, and it's not particularly the forum in which to debate all the facts, but the select board never considered anything about this.
He definitely did at that meeting.
He brought it up.
It was,
He said that he had heard from you. There, no decision was made by the select board.
Well, I just think to really be clear that as a select board, that is your format for reviewing things with your town manager in a public format. And so it was not acting as his town manager, he was acting as the road commissioner. And the road commissioner was the one who set up the review process in which we submitted our proposal for the road and the vehicles. And he said, and Herb told me, he said, we met 3 times I mean, we had a very long review process and he told me bringing it to the select board was a formality. And that typically in a road commissioner capacity, he brings it up in the capacity which he did at that select board meeting in May. And that any concerns could be vetted at that point. And so as part of his process, which I don't know how many times these, like maybe this is the first road commissioner's proposal in the last 5 years. But that was the system that was laid out for us to how to review it. And so never in that process was it, there needs to be a formal select board vote on it because the determination was the road commissioners to have. And it,
I don't actually think that's true. I think the last sentence in his letter was that this letter did not change the status of the road. And even the select board does not have the legal ability to change the status of the road, which is why at town meetings in 1889, 1975, 1996, and 2009, different decisions were made about that road. So even if he had us weigh in or tell him what to do or whatever, which he didn't,
but
we don't have that power.
I mean, I think you can't deny the public record that there was a discussion and we can bring out the meeting minutes because I know Brandon has reviewed it, but there was a public select board meeting and Brandon, as the up and coming town manager, was present at that meeting because he was involved in the overlap. And so it honestly, I had to go back to the record myself to fully understand the process that it took. But it was my understanding that as road commissioner, and Bill, this is where I look for your legal guidance, in his capacity as road commissioner, he issued a formal letter authoring us to put utilities and to improve that road. And so, I think there needs to be some clarity on what the road commissioner's capacity is in this town, because I mean, certainly from our perspective, like, I feel like we did go through that process, and I do know it was at a select board meeting. And then I do know that he went through the record. I believe he talked to a few abutting property owners. Like there was a process that happened, and I just feel like we went to that end of the process. And I need to know a little bit more about that process because it did seem like an official one to me.
The action items at the May meeting, when it was brought up, was that Rick was going to consult legal counsel, Bill Kelly, on this, and he would follow back up with the select board. That didn't happen. He consulted Bill, but it was never brought back to the select board on an agenda. Now, you are right that, from my understanding as well, that the road commissioner can approve road plans when there is a public right of way there. Bill's advice to Rick was that whether or not there's a right of way there is unclear, and that the town should not act in certainty one way or the other at this point.
It's like,
Yeah,
how many-
we understand that you relied on words in his letter. And so that's why I don't want to make it like a contest of.
It's not, because I was asking for the town attorney if he could represent what the road commissioner's capacity is in the town of St. George specifically, since that is what we're discussing. Could you help us, Bill?
Yeah, and I appreciate what you said and the fact that you made these efforts and you made these contacts and you got that letter. I get all that. But he couldn't change the status of the road in terms of what rights you do or don't enjoy. And that is a complicated question. And to the extent that he tried to make it uncomplicated, he might have reached too far. But a road commissioner has no authority to change law. And as Jane was saying a few minutes ago, we are stuck with the 1889, the 1975, the 1996, and 2009 legislative acts at town meeting. That doesn't make you any more comfortable or happy, but a road commissioner cannot
So what
wave a
does
wand.
a road commissioner do? Capacity of road commissioner in the town of St. George. Could you give me an example of approved capacity they can act at? When a road wants to get posted, is that a road commissioner versus a select board? I guess it's just helpful because we were under this assumption of what the capacity was of the road commissioner. And I've looked through the town of St. George ordinance and I go back to the Maine statute and I go back and forth. But what's not clear to me is specifically if St. George has its own guidance to the road commissioner outside of the Maine state law.
I'm not aware of any, that,
Okay.
that there's anything unusual in St. George that has any kind of ordinance. A road commissioner is what it sounds like. It's the person in charge of monitoring the roads. They serve at the discretion of the select board. They're appointed by the select board. But they don't have any legislative authority.
So the issue here you're saying is just that maybe the road commissioner didn't know it wasn't a road.
I don't know what he thought when he
It's,
wrote the
like, is that like basically what you're saying? He was like, I thought it was a road, but it wasn't, so I shouldn't have told you that.
I asked him.
It's
when he wrote
kind
the
of
letter.
lame. I mean, it's got people have.
So if we go back to one thing that he definitely did say in his letter is that we have authority from the town of St. George, but utilities through the town right of way. So in terms of that, we have looked into that a little bit more. For us to put utility poles in the town right of way, we need town to sign off on our poles being placed in the town right of way easement. Based on that, I would like to know if that portion of the road commissioner's formal letter to us is that an official capacity that they can say, yes, you can put your poles in the town right of way?
Can I add a clarifier? I think it's helpful. And the pole that Zell is referencing is within the first 1,300 feet of maintained English Town Road. It is
In
not,
the easement. It is in the public easement of the part that we already maintain.
yes.
Okay.
And then the next pole would be on her private property. Is that correct?
That is correct.
So
Yeah.
it's not in the right of way that
This is
is,
a problem.
it wouldn't appear to be, but I don't,
Yeah, I guess I'm just looking for Bill's take. So it's the portion of Herb's letter that identifies permission to set utility poles in the right of way there. Is that portion officially approved by the town, or is that also something that would be questioned?
Well, it isn't what the letter says.
Okay, well, maybe we should all read it. So you're saying you don't consider his letter to give approval for utilities?
It doesn't say that.
Well, it says it approves his proposal from us, but I guess we should.
Which I haven't seen.
You do not have a copy of proposal.
I don't know which.
So okay, here, I've got a copy of it. I thought it would be important to include in that record. So because he does reference that he's approving our proposal. So this proposal is dated April 23rd.
Mhm.
And it identifies our proposed improvements to the road and then the electric service. And so my interpretation of his letter is he's approving our proposal that does include a map on it. So that's your copy. You can-
I understand what you're saying, but no, I don't think that the road commissioner has the authority to approve utilities in a public easement. I think
Right of way.
Public
Public.
easement.
So, sorry, what's the distinction between a public easement and a public right of way?
Well, a town way, sometimes called a public way, is a road that has been taken like it was in 1889 through a legislative act, and damages are paid to the property owner who's now burdened with that road. Somebody put the roads have to go over somebody's property. And that's what's called the burdened parcel. And when the roads are laid out as a town way or a public way, the reason damages are paid is because now that private landowner has public traffic going over a portion of their property. So that's called the burdened parcel. Under Maine law, when a town way or public way is laid out, the town has the obligation to maintain that road. That's an obligation of all towns, and that's the distinction between a town way and a public easement. With a public easement, the town does not have the obligation to maintain it anymore, which if we look at the 75 warrant article, the original article discussed no longer, I'm gonna get my language right here, so bear with me a second. There was a slight distinction between the article as drafted and then the article as amended. And These are important concepts. So the original article said, this is in 1975, to see if the town will vote to discontinue the Long Cove Road, which I understand is the Englishtown Road, starting in Smalley Town on Route 131 at Marie Peterson's driveway to Wilfred Carson's property northeast corner. The way will remain a right-of-way, the abutting landowners. That was the original warrant article. What typically, and it could have been said better, when it said the way will remain a right-of-way for the abutting landowners. That would have meant, in my mind, that equals a public easement being retained. It gets confusing because public easements used to be called private ways by statute. And if you look at 1889, these private landowners were asking to have this road laid out to their property. So sometimes those things were called private ways. That's when the town does not have the obligation to maintain it. So that was the original article. And then the amendment said, so the first one was fairly sort of in a way more typical, to discontinue the Long Cove Road, meaning a public way or town way, I think. The way will remain a right of way for abutting landowners. We're going to basically change the status of the road from a public way or town way to public easement. That appears to be what they intended. When it was amended on the floor, which they did not really have the right to do, because when you create a town warrant and you post it, people get to rely on it, and you're not supposed to change it at the town meeting, because it's a very official document, a town warrant. It's not supposed to be modified. And people can just change what it meant. People who stay home, don't want to go to town meeting, have a right to rely that the article is written is all that is being voted on, not anything else. That's why there's so much notice beforehand to say what exactly is the town meeting going to vote on. So what they did was ignore that rule and say, the article is amended to read, to see if the town will vote to discontinue expending town money for automobile and truck traffic on Watts Avenue Road from the southern corner, da, 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 da.
That's the other one.
That's the
I'm
difference.
reading the one above it. The article is amended to see if the town will vote to discontinue expending town money for automobile and truck traffic on the Long Cove Road. Discontinue expending town money for automobile and truck traffic. Is that the same thing as saying that the town is that the status goes from a town way or a public way to a public easement? Maybe. But they didn't do that. Instead, the article goes on to say the town the way will remain a town right of way for horse riders, pedestrian, and bicycle traffic. Very different than what that first article would have done before it was amended. The first article, as it was amended, it seems to me, would have gone from a town way to a public easement. Instead of focusing on the concept of a town way, they said, we're not going to pay town money for automobile and truck traffic. Maybe that's the same thing, maybe not. But what was very different was this language that was similar to a bridle path or a bridle road. So, I don't recall exactly why I was going through this distinction.
I think we were asking the question, Rick Erb's memo to us, and I have a copy in front of me, June 30th. And for everyone who doesn't have a copy, I will read it. Dear Zell and Dan, I am in receipt of your proposal to improve a portion of Englishtown Road right of way that was discontinued for town maintenance by a town meeting vote in 1975 and clarified by a subsequent town meeting vote in 1996. Under Maine state law, abutting property owners are allowed to make improvements under such circumstances, and as town manager and road commissioner, I am approving of your proposed work you have described in your memo dated April 23rd, 2024, which your attorney now has a copy of. The town's approval of this work in no way changes the status of this portion of Englishtown Road, and the town will not be responsible for its maintenance going forward. I just want to be clear, it specifically does discuss that proposal, and I think that's how we got on what you were just saying.
Right, okay, and I understand that.
So I guess my question was, is the road commissioner not allowed to approve the proposal? Like, are you saying everything in this letter from the road commissioner, like, doesn't actually stick?
I think the story is more complicated as I wrote in my memo, and I understand you'd like to say that that was the paper, and it may be true that you relied upon to do your improvements. What I'm trying to say as clear as I can is a road commissioner who writes a letter to someone like yourself cannot change the status, the legal status of the road.
And I
And
think
he
he
says he's not.
identifies that.
But his point is that, yeah, they're not going to maintain it. I mean, it's the same
But
sentence.
I think though that Bill's point and the history of things like the warrant article being changed on the floor. The status when Rick wrote you that letter was unclear, you know. It's and even to ask a judge today, what was the status in 1975 after that meeting? That's not clear. Then there were actions in 96 where they were trying to clear it up that weren't necessarily helpful. So, you know, I know Rick said what he said, and you acted believing that you were in the right to do that, but he did also say he couldn't change the status of the road. So it's we're all in the same boat, that none of this is clear or easily resolved.
And so my question specifically, I understand the status of the road, but the utility question in the town right of way. My question is specific in the sense of the town does need to sign approving that pole being in the town right of way. It is surveyed, it's at the registry of deeds. And I am asking the select board, given everything we've been through in this discussion, can the town vote to give us permission to put the pole in the town right of way? Can that be done formally? Because certainly we don't want that to come up again. And it sounds like since we originally submitted this request to the town and we thought this process that it sounds like you've done in the last 3 months, we thought this process happened, you know, a year and a half ago. That was our understanding because it was a 3-month period, similar time frame. So given all that, I guess I'm just asking, like, can you make any, like, are you gonna prevent us from putting our poles in the town right of way? Will you not be signing that because you don't feel comfortable with the history?
But again, this is the undisputed portion of the road. This is the first 1,300 feet that are clearly a public town road, just so that.
So in 75, though, wasn't it considered a road? Because they said they're going to discontinue it as a road. So before that, it was considered a road, went out through there, right? So wouldn't that leave the same right of ways to the people that bought property to use that existing?
And I
as
think,
a road?
as Bill said, though, it's described 4 different ways prior to that. You know, in 1889, it's described in 3 different ways alone.
Of time advances, so in 75, though, it was considered before 75 as a road. Which
Right.
means it's a right of way for people to go down through.
I
Somebody
understand.
built a bridge.
It just would have helped if in 75, when they discontinue it, they didn't have that language about horses, bicycles, and pedestrians. And just to sort of flesh this out, because I know you're frustrated, and I understand why.
I'm just looking for clarity.
Right,
That's
well-
really what I'm looking for, and I don't know if we're getting it.
Well, exactly. That's the purpose of my letter, is to say it's very difficult for anybody to have a perfect answer, but I want to answer your question. Just give me a second. So I think if we were to pinpoint, which is what Jane was talking about a few minutes ago, under Maine law, I'm reading the letter now. Under Maine law, abutting property owners are allowed to make improvements under such circumstances. I think what he meant when he said that was that when he was reading the 96 article, the clarification, he thought that was the controlling document and that a public easement had been retained. What I have laid out to you is that may not have been the case. Because in 75, when the town did what it did, it created the status of the road at that time. A 96 article can't create more public rights just because people put their hands up.
And you used interesting language in your letter to describe that. You said that the law can't claw back anything, any rights would have been ceded to. What was the word?
Abutters.
Abutters. So
So
wouldn't
are you-
we be abutters in that case? Like, I just don't understand how the town never ever votes to give up on public easement. Like,
The
in
rights
all of
would
those-
be to the extent that, what I'm talking about is the rights to the extent that you actually abut the road.
which,
We do
Yeah.
abut the
By
road.
how many feet?
I mean, we have a long.
We have, I mean,
Right, but you're not trying to get over your own line.
Well, so
We
I
ab-
guess
So
is your point that an abutting property owner can only maintain the road on like the physically abuts? No, because you would be able to access.
I'm talking about what does it mean in my letter when I say clawing back
I
rights?
don't know.
That's what I'm
It's
saying.
colorful. Okay.
okay, fine.
Bring back rights to you that were, to the public, I should say, that were given away. When a discontinuance occurs, then certain rights are ceded to the literally abutters for the amount of frontage you have on that road. So you've got 300 feet on the road and there's a discontinuance. And typically what that means is you now have all the rights to the center line of that road. To the extent that you abut it, not somebody else's land that you cross over. It's not all butters for all purposes, all abutters for all purposes. So that's what I was talking about, would be collectively, all the abutters would have taken little pieces of the road upon a discontinuance, and they'd have the rights to the center line and the public rights would be extinguished. That's not what happened in 75. Clearly, they said something about bridle rights, basically, with pedestrians, horseback riding and bicycles. So to sort of play a little devil's advocate of your use of this herb letter, I don't know that he fully understood the circumstances at the time that he wrote the letter. He was assuming he did, which is why this is a dangerous thing to do for a road commissioner.
Mhm.
And for you as well to be part of the process and think you can rely upon it. It's just more complicated than that. But back to your question, a few 20, 30 minutes ago, when you said something about accessing your own property. There's a whole nother layer of issues here, which are private, which have to do with more uncertainty as to whether or not you as a private landowner have rights to go over the unimproved portion of the road on someone else's property. If those rights no longer exist or never existed for traffic, vehicular traffic. That's another complicated question that overlays this. And another reason why, on the private right side of it, if you can all come to terms, you and your neighbors, that makes a whole lot of sense.
So what does that look like to you, Bill, when you say us all, what does that mean to you? Like, when you say that, like, what does the outcome look like based on that hope?
The outcome would be for the portion of the road that is not maintained by the town, that burdens, that's on someone's private property that you wish to cross over, or other people wish to cross over. The simplest and most direct way to resolve that is through a combination, basically an agreement
Mhm.
of all of the abutters, including the person whose property this road goes over, to say what you could do, where, and who gets to use those rights. And probably there'll be what I call the pertinent rights, meaning they run your land. So when you go to sell, you'd be able to sell the easement right to go over this private piece of property. That would sort all this out. If you could all come together and do sort of a single agreement based on a survey of use over the portion of the road that's in question, make it clear that it's for vehicles, have the property owner upon whose land this road is located, give these easement rights out, and in turn, create obligations for maintenance, maybe give the property owner the right to use the road as well for his purposes, and have sort of a deal that works. And that can be all kinds of things in terms of a deal that works that should be at least discussed among the private property owners, not necessarily here. But there could be benefits on both sides that make it work. And I'm suggesting instead of a big, long fight, that would be a good way to do it. And it could be a single document signed by all the abutters, including the property owner. It's recorded in the registry of deeds. And now you have those rights established without any concern about public use or public maintenance or public abandonment in the future. Because those would be rights that run with your land. If you could come to terms in an agreement and record it.
Theron, you had your hand up earlier.
Yeah, I was gonna talk about the pole that she was talking about.
Mhm.
That's in the survey from Dorsey. And I talked to him about it. The center line of the English town, the maintained path. It's a pin at Judy and Billy Johnson's common. And he measured from there across the road 25 feet. And it comes short of the pole. But the English town makes a corner at that point. And it was unclear to him whether that 25 feet included that pole. What he needs to do is put a pinch pole in. And I told Zell that if she talked with Brandon and got easement for that from the town, that I would give her an easement on mine also for that pinch pole. And then she wouldn't have to resurvey it.
So Bill, would you,
Well, the select board could, that's not a complicated thing to do. The select board could provide that permission to the extent that you have the right to do it and conditioned upon the property owner doing it as well. It wouldn't be a complicated document, I mean, a motion, really. If that would solve that problem.
It's unclear if where the pinch pole is going is actually on the English Town Road or on me.
All right, well, if you're willing to do that, we can work that out.
Yeah, I'm going to work that out, but
That was the thing I was hoping you could vote on. So we could have that formalized so that this doesn't get reopened. And I.
so that would resolve the electrical pole.
I mean, that's one slice
So-
of the onion, but we'll divide it out. This is the pole here,
Maybe could hold
and
it
it's
up.
sort of unknown where it falls in the town right of way.
So that's what Theron's talking about as far as.
And that's within the 1,300 feet of
So-
that has been.
And since it's in the part that the town does maintain, that's the reason you're saying we could approve this by motion.
Yes, I mean, so we don't have this again, you'd want to have something before you. It's not an agenda item tonight. And you want to make sure you have a clear location based on the survey that you're approving. So you know what they're,
guy,
what's that?
the CMP guy come from the 1,300 feet back. 250 feet because that's what they can go on a 40-foot pole. And it left 77 feet, so it's 327 feet from the end of the 1,300 foot mark. I don't know if that makes sense to you.
Well, that's what we'd want to describe with some clarity, so you all knew what you know what you're giving them.
I think
The town
it
does.
would be helpful, and it does seem like tonight, since it is an agenda item, that the town could vote on this. It seems within the capacity based on my read of it. I would like to hear the town say that we can set poles within the town maintained portion of English Town Way. That would make us more comfortable moving forward with our project. Because what has happened is, since this has come up on executive sessions and discussions, Brandon has expressed, and I completely understand, but he's expressed some concern with kind of negotiating some of the CMP easements. And so I think it would be helpful, not only for us, but also for your town manager, if you could support him in that as an ask tonight. And since we are here in the select board meeting, I would imagine that could be voted on.
But I guess I'm wondering, Bill,
It's
if,
not ready to be voted on. We don't understand quite what. It might make sense to you, but I don't think it makes sense. It doesn't make any sense to me.
Brandon and I have certainly discussed it, so I think your town manager was trying to kind of elaborate on it.
I think we understand and support the concept, but it seems like the description of numbers of feet and from pins and things like that. You know, that's why we need to have something in front of us.
I mean, I have it right here, but I think they're looking for something more official. But I was under the impression, based on discussions with Brandon, the select board was able to vote tonight on Englishtown Road. But I
Well-
guess that was misunderstanding, because I came here tonight with a very specific ask, which does prevent us from moving forward with their project. And the reluctance from the town, given this sort of reopening of something that we thought resolved, it seems like it's a small ask to say we can put a pole within the town right of way. I-
Want one pole or multiple poles?
I think it would just be one pole, but I would like that to be voted on, that flexibility. It seems like that's pretty clear and it is surveyed. But you're saying you don't think the select board can, I mean, at this point, I think knowing the past history of the road, I'd love us to do it correctly. So if that takes another meeting, I think it's really important that we move forward with clarity for not just us, but for the next generation. Because this question is going to continue to come up unless it was resolved in a clear way, and it's not issuing a letter and then retracting that, because that certainly makes it complicated.
Well, I
And
agree
it's
with
not
you.
just
Clarity is
Sally
good.
with interest in this road, because Bill Johnson has a child, well, grown adult who's gonna be moving out there. Elliot has a right of way off of that property to access his, and I still have more property out there.
Well, again,
So-
we're only talking about the public right. There, as Bill said, there are private rights that will remain separate and do not involve the town. That can be carried with properties as well.
So there are a couple things. One is the electric pole issue, but then there are the issues that Ms. Johnson is talking about. You know, access to the properties beyond where the town maintains. And that, to clarify that for all time, would require all the abutters and an agreement like Bill described. And we haven't heard from the rest of you who own property back there about whether that's something you're interested in pursuing. And if it is, you know, that's great. This meeting where we have other things we need to be doing is probably not the place for that, but it was important for you to hear from Bill how complicated this is. And it really is unfortunate that Ricker wrote you a letter, that you relied on it, and that it didn't take into account a complicated history of over 100 years with different decisions made by at different town meetings. You know, it's unfortunate that this is where you all are, and we are too.
So is the town offering to draft that easement that Bill thinks is gonna solve this situation?
Well, I don't think we're ready to do that until you all get together and talk this through in the neighborhood. And I don't know how many property owners are involved. I think it's up to the select board as to how much involvement they want me to have, but it's a bit premature for me to draft something.
But you were asking about the electrical pole thing or
Well, I
the
guess
bigger
that-
thing?
That would be a helpful thing. I guess I'm just wondering what the town's role is going to be to help resolve this. So I think certainly it seems like, you know, I don't know what action item the select board was going to take on this.
And I think that was the purpose of tonight's agenda item, right? Was to decide whether or not, if the town felt like this needed to be resolved in some sort of permanence, and for all property owners, then they could decide to open up the lawsuit to send this road to court and get a judgment on the status.
Or if the property owners are interested in engaging in working together on an agreement, which would be way preferable, I think we all agree. It would happen more quickly, it would cost less money for everybody. And so I think, you know, that is the question for the property owners from English Road West. Are you all willing to work together and try to get something done that for your heirs, your people you might sell the property to, this is resolved for all time, separate from going the lawsuit path.
I was here tonight to tell everybody that me and Val had come to an agreement. And the paperwork isn't written up yet, but, I think she's got that under control. I think it should be shortly, so.
Oh, good to hear.
But that still doesn't address the people beyond.
Right.
Yeah, I mean, I agree. I mean, Farron and I have been talking about this ever since the town sort of changed their tone about our rights. We have had numerous discussions about it, but I think there's still an outstanding issue that falls on the town here, because as Billy identified, there's decades, centuries of missteps here, and I just think that, I mean, it's a nice, and we're working on it, but I think some clarity would be helpful. And so I do hope that the town does see that as an action item to understand the road, because I just think the due diligence didn't happen for us a year and a half ago, and I
I
just think
just
it's
don't
important.
understand why it would change now when Billy put his house out. Darren and I built the garage out there. Judy's put her house out there. And now all of a sudden it's changed on the road status. And it was always,
Maintained up to.
well, Billy maintained it by himself. And when so many people moved out there, they asked the town to take over. And that's what we assumed would happen with the rest of it. Because there's only so much land left in St. George, and you can't halt progress.
But we can't undo the decisions made,
So
you know,
can
way
we-
before our
can we
time,
have-
but we're stuck with it. And I think it's in your hands to come together and do something. And we certainly will, you know, we support you in doing that. And it seems like Jane said, if you can avoid court, it's always a good idea.
So would support be that the town is offering to pay some of the legal fees for the easement work required? I don't know what type of support you meant. I was just looking for clarity. Because certainly you can imagine we're all getting a bill for this, including the town of St. George, so.
There's 6 months. Beyond mine and Zell's and working out an agreement, there's also the question of in 1890, when they bought this, they didn't have electricity. So did they buy utility rights?
Typically, if a road was taken for highway purposes, which it might have been, then those rights, yes, would go with the taking, because that's how things evolve. Highway purposes included such things as it evolved. That's why you see utilities in every public road you drive along. They didn't get extra takings for those types of utilities. So the short answer to your question is it depends what happened in 1889. But yes, even though electricity wasn't there then, it may include it.
Do you know if this road, when they bought it, was an easement interest or a simple fee interest?
It would have been an easement interest. It's a presumed easement interest unless the taking stated otherwise. So it would have been pretty much the same as almost every road in this town, an easement interest. Very rare did either a county commission or a select board take a fee interest when a road was laid out. Very, very rare.
But then the fact that they discontinued it was a big change, right?
Something happened, that's for sure.
Right,
Well, again, we don't know the status of the road.
right,
Tonight's
right.
goal is to figure out what the town's path forward is, recognizing that some resolution should be arrived at, and recognizing the town's own mistakes in the process over 130 years. And so now, if there's a desire that I have heard expressed to get clarity on it that is a bit more permanent, and what we're trying to figure out is what the urgency on that is. Meaning, if Zell's project is dependent on this getting clarified, then we should likely not wait on it. That being said, if there is not urgency, if Zell's able to continue her work and we can build this into a budget, because it will have additional legal fees, and we're already experiencing more legal fees than we anticipated this year, then it would be preferred to do it that way when we can plan for a court case. And so I think that's really the decision tonight, what the
Well,
urgency is.
but you're still assuming that it's just those two options, and I think there's still the communal resolution option. But you know, it depends on the Fallas and the Johnsons and the other property owners who haven't really said, you know, Zell and Theron have said they're willing to work together and resolve this. If you think other property owners to the east, you know, of where the town maintenance ends are willing to work on something that would resolve this for all time via agreement as opposed to a lawsuit, I do think the town, I don't know, for myself, I would say that would be in our interest. What do you guys think?
Yes.
Yes.
Yeah.
Yes.
So,
I guess I think maybe you all are more optimistic than I am that 15 property owners could reach, agreement on this. I didn't maybe consider that realistic.
They can't be too interested.
well, so
Right now, Zell is the one
Right.
with the problem. And I feel very bad for her and, Dan, is it?
Yeah.
I feel very sorry for him. But if that doesn't solve the problem. But right now, if Zell and Theron can come to agreement, then that relieves them of their problem. And the landowners that aren't here tonight, they aren't worried about it. They'll let them deal with it down the road when it comes that time.
right, that is one of our options that, you know, if you two are willing to work out your resolution.
Won't spend more money in lawyers.
No, we don't, Theron. No, we don't.
You know, that's why we've decided to come to an agreement.
Yeah, and I will always speak for myself. I think if the town's willing to pay a portion of the settled agreement between Theron and I, we're happy to submit a number. But I think some of, you know, if there was legal fee or precedent for supporting the easement, I think all parties would like that, because as Theron pointed out, we have both spent a lot of legal fees when we already went through the process. So I don't know if that's something the select board wants to think of. We can certainly submit a letter. But I just wasn't sure sharing that what that looks like.
Well, obviously, the town would have to spend money if there were litigation. So recognizing that the town taxpayers would have some expense to bear, I think it's, in my opinion, reasonable for the town to share in the expense of getting a resolution. But that's my thinking. What do other people?
Wouldn't that assume that we wouldn't then spend the money eventually on the legal? You know what I mean? It's not eliminating spending the money on the legal.
The longer to the other piece, you mean?
Yeah.
No, it's not, but you know.
It's
Ricker,
paying
Ricker-
twice for it.
That is complicated
I
Bear some
for the
responsibility.
town.
Yeah.
And
Maybe that's something that
we can work out.
Brandon can have further discussion about. I think
Yeah.
at the moment, the low hanging fruit is sharing the survey that
Mhm.
depicts where the pole is. And having the select board get a resolution together regarding the pole issue, just that one issue,
Mhm.
which Theron is willing to give an easement for. If the town and select board is saying it can go there. And we just start there, but we need to see where it is, so we can properly describe it, not just on a piece of paper tonight.
Well, so it falls between two surveys, so that's what complicates it. The pole is on the Beal survey. The Gartley and Dorsey survey does not show that pole, so it takes taking two surveys
Okay.
and bringing them
So
over. But
that's
I'm happy
probably
to
more
distribute
in
that.
the weeds than we should be right now,
But
though,
it's a
right?
possible future specific act that the
Yes.
select board could take to help that one issue.
CMP's in the air, whether it's on the English Town Road or on the
Right.
It's close enough right where it makes the bend in the road.
Right,
If the bend swings that far, then it would be in the right of way.
right,
If the swing continues and goes around, then it's on me, so they want easement
right,
for that pinch pole, which is just a brace off a pole that's existing there.
right. Okay, so we don't have perfection, but we can have a vote by the select board that says to the extent this is within the English town right of way, then we're giving permission. That's not a complicated thing to draft.
Okay, great. I will submit that to Brandon. Thank you. I
Okay.
appreciate that.
And then if you hear from other neighbors that they want to be part of a global solution, you know, we'll be happy to entertain that. All right, well, thank you, everybody. I know this was a lot of interesting history for others who were here for other agenda items. So we'll try and leave quietly if you're leaving while we move on to, thank you, Bill, the rules proposed by the cemetery committee.
Good night, everyone.
Good night.
Thanks, Bill.
Thank you, Bill.
Hey, Bill. A lot of folks turned out to be bad home, but they were represented. They didn't clearly live out there.
So, we have been provided with proposed rules and regulations for the cemetery by the cemetery committee, and
Just say yes.
well, I guess I wanted to ask whether anybody on Zoom had any comment or question about the proposed rules. They were posted on the town website. And this is our last time to talk about them before we're gonna vote. So I'm not seeing any hands raised. So then, opening the question up to the 5 select board members. I know the sticking point for some of us has been the different prices for people who don't live or own property in town. And if you could just say for us and for the minutes, what your rationale was for charging 3 times as much to people who don't live or own property in St. George.
Speaking for the committee, I believe that because I have spoken to many folks from out of state that have wanted to purchase plots and have purchased plots here. And they have said what they would have to pay in their states, and even at 3 times as much as what if we charge that much, it's about half of what they would have to pay in their state that they spend most of their time in. And the cemetery needs a lot of, we have limited space left. And we need that space for our full-time residents, you know, the ones that are here. And whether this keeps them from purchasing plots because they don't want to spend that different rate, then that gives us more plots for our residents. Or they pay the money and then that helps with lots. We have a list of repairs that need to be done that haven't been done in several years. And so we're looking at a way to help get this stuff done. And like I said, we are limited, or we could go and not sell to any non-residents. That is, you know, an option as well. But those are our reasons behind this.
Well, I guess you've brought me around about the triple price for the non-residents. And I have a friend in the business and he said, think of it as paying the last payment for out-of-state tuition. That's it. So I'm okay with that, but I'm still not okay that non-residents are excluded from those larger plots. I just think the rationale holding it for somebody who may or may not buy it, I still have a problem with that. And I still have a problem with looking into green burials there. People in that area drink from wells. Not everyone's on the water district. And water quality under cemeteries is always compromised. So, on one hand, you're saying, well, green burials, they're not embalmed, they're in pretty wicker baskets. And I mean, it's a romantic notion, but I'm still uncomfortable having any sort of green burial at that particular cemetery. And maybe in all cemeteries in this town, because of the fact that we drink from the groundwater table. So when people are in wicker baskets, then their parts to their body, pathogens, medicines, may reach the groundwater table, and we may have compromised drinking water standards for our residents. So that's where I remain thinking about the proposed rules.
Well, in the proposal, it says they're just gonna look at green areas.
I know it does say that, but I'm still against that. I really
You
am.
don't
I
wanna
really,
even look into it.
no, I think every town in Maine that has people drinking from well water should not be looking into green burials. It's different if there's a large water treatment plant and somebody's really monitoring water quality. But in our town where we have people drinking from the groundwater table, and in that case, there's people like 100 yards from the cemetery who drink from well water. So I still remain against thinking about green burial. And I understand why it's attractive. Anytime you see it on TV, it looks really pretty and it makes death look less harsh. But as someone who's interested in water quality, I cannot approve of that.
And I think that could be like the first consideration. I mean, I know you've already had people come talk to you about it and looked into it, but it
They
does seem
came and
like
did a presentation to get us to information, and we are having them come back. To get more, because this was our first introduction, we didn't know anything about green burial beforehand. And I do have to say that the folks that live right there are on the committee and are excited to learn more about the green burials.
I don't know if you were here at an earlier meeting where we discussed the fact that in the next few months, we are gonna have a community conversation presentation about water quality. And Sarah Oaktai, and others who know a lot about water quality will participate in that. And I think it'll be really important just to hear about the water quality issues. Did other people have comments or issues they wanted to raise about the proposed rules?
Don't have any concerns.
I think, did I send you an email? Yes, I sent it to you guys saying that I thought that in the document of the proposed rules, it should explain the reason for the difference in the rates. That it's twofold. First, through their rent or property taxes, residents have helped pay for the cost of maintaining the cemetery. And second, as of this date, there are a total of fill in the blank
Right.
lots
Right.
that are unsold. And that the town wants it to be more affordable to residents to buy the remaining lots, something like that.
No, I don't think we say that to people who are with paying mooring fees. We don't do any lie. We just charge them more if they're from outside of town.
But they're, right, but I think. I mean, we don't have to explain it in there, but I think if is a good reason for it and it's in there, when all of us aren't around.
Right, and I think if it's in the guidelines and when I'm no longer the sexton and the next sexton is there, hopefully it's explained. There's enough committee members as well, or, like, I didn't just jump into this, not knowing, and believe me, there were no guidelines, there was, I went by word of mouth from a couple people that have done it in the past, and I still talk to them. But, also knowing that, I have long conversations with every single person that comes to purchase a plot or even look at plots. And a lot of them, they asked about, the different sections that are available and, they could be 5 rows away and they're concerned about the view or where their people are gonna come and, and sit and, and this is why I know that how much they would be charged where they live, because we've had these conversations. We've done our research, but I've had these face-to-face conversations and they're the ones that are like,
So
oh,
then,
my word, that is so deep. And I'm like,
so there are really 3 reasons then. The third reason being that it's a market, these are consistent, the higher prices are consistent with many other communities.
but I'm not sure, like you said, I'm not sure how much needs to be
Right.
posted or, in the guidelines. And it may change down the road, and I know that all comes with something, but right now I have very personal conversations with every single person that comes to the cemetery.
So, does somebody want to make a motion to approve the proposed rules?
I will.
Second?
I'll second.
All in favor? So any opposed? And you would support them if we took out the thing about we're looking into green burials?
I also don't like the exclusionary of the large plot.
Okay,
If that was charged at triple the rate as the other ones, I would feel more comfortable with that.
Yeah, but it's not necessarily a large lot. They could be sold as smaller lots too.
But the one on the proposed rules, the largest lot, people who are not from this town are not allowed to buy that. The largest one.
A
But they-
lot of 6 plots.
Yeah.
but they could buy 2 or 3 smaller ones? Is that right?
And yeah,
Exactly.
So you could cobble some together, you just can't buy the one big one.
Well,
and
let's,
our concern was of, holding, the price is a lot less, than somewhere they could get it somewhere else and holding it for possibly, family members that have not been here even.
Oh, I see. Right.
And that is our concern. And these are our proposals. I'm not saying that they have to be this way, and if everybody else is strongly concerned about that, but I am concerned because of our lack of space that we have left in our town. That is our driving force.
Okay, well,
We're gonna run out of room.
we did vote
it's approved.
and it was 4-1, but I did want to clarify with Wendy before we left the issue. So
Yeah.
that kind of the record is clear.
Thank you for yours and the
Yes.
committee's work.
Thank you for all the work you all did on that.
Great job.
And I'm really glad that the committee has been revitalized, that you're doing this work. as we learned recently, it's great that you'll move on to mapping and other things since we found a discrepancy in
Yes, right.
where someone's
Yeah, there's a
expectation
lot of
was
work that needs
versus,
to be
Yeah.
done down there, and we're on it, so.
good.
But at least it's not English Town Road.
Yeah, no. It was cleared up much more quickly and easily and cheaply. All right, so the next thing on our agenda is to talk about the open space committee. Steve
And
and,
Ken here too.
yeah, Steve and I and Ken Oberger have talked to, I don't know, 10 or something people. A remarkable number of people have expressed interest in serving on this committee. I got an email today from a new person who's interested. So, I did look at the town charter and the select board policies about numbers of people on committees. The permanent committees that are mentioned in the town charter, like the budget committee and some others, have to have 5 people and 2 alternates. The Board of Appeals, Planning Board, the Conservation Commission has a statutory number. But as we did with the Parks and Rec Committee, for committees that are not permanent committees of the town, it appears to me we can have more than 5 plus 2 alternates. So given that we had this big number of people who expressed an interest, Ken and Steve and I thought that we would recommend having up to 7 full members and 2 alternates on the open space committee. And then we do have a number of people who have agreed to be support advisors. So Michael Jordan from the planning board will attend to help them with possible ordinance changes. Ken's willing to serve as a representative from the Conservation Commission, Bill Farkas from the Comprehensive Plan Committee, and we're still hoping there'll be somebody from Parks and Rec who'd be willing
Put it out there.
to at least, even if they were involved in a limited way about recreational property.
When I put it out there, we were pretty busy.
I know, we've been distracted with Parks and Rec, so that, but if somebody's willing to serve and not need to be formally nominated and go to every meeting that happens, we might persuade somebody.
Stuart Witt, by the way, who's on the commission,
Right.
said he would help with mapping, but
Yes.
not in an official
Right.
capacity.
Stu Rich has been very helpful with GIS mapping and other ways for the town. So, and we do, Dale is here.
Is here, and if we have plenty of people, I'd be happy to be an alternate. And
Okay,
Ally would be a great, person. She's on the Conservation Commission. I believe she's interested, so. I would
okay.
feel perfectly comfortable being an alternate or not.
So then, the people we would nominate to be full members right now would be Ryan Aponte, Katie
Did
Berglund.
you ever hear confirmation? Because I haven't.
No, but if she changes her mind, then we just, Sue Merrow, Janine O'Brien, and Ally Wood. And then for alternates, Ann Cogger and Dale Pearson. And then that leaves 2 people that have said they're interested that I haven't had a chance to talk to.
I'd just suggest that Ann definitely wants to be on it, right?
Oh, she does,
And yeah,
instead of being an
and
alternate.
I would swap with and make Katie the alternate. Because I haven't heard anything
Back from her. Okay,
affirmative from her. She
Okay.
was interested, but she didn't.
all right. So
I haven't contacted her.
Who did you just say?
Katie Berglund.
Oh, Katie Berglund, okay.
So, and I'll provide that information to Patty St. Clair, but so that's my motion for members of the Open Space Committee, knowing that we will be back with probably some other names.
Who was this second alternate?
So the alternates would be Katie Berglund and Dale Pearson.
Do you need a motion for?
I made a motion. You want to second it?
Sure, I'll second it.
Is there any discussion? All in favor? All right, I will notify all those people. Janine, I see you're on Zoom, so you've just been nominated to serve, and thank you for listening to all the interesting discussion we had before we got to this. I also
Thank you for the appointment.
I had also sent all of you a proposed charge for this committee, which I'm trying to find. Is anybody? I'm not finding it. Can you pull it up on your computer?
Sorry, I should have printed it out.
Well, I thought I had it in my pile, but I'm not as focused as I had.
And the rest.
Thank you, Ken. All right, so the proposed charge was the charge of the Open Space Committee is to develop an open space plan for the town. This will include defining the term open space, identifying properties regarding which open spaces the community would like to see conserved, developing strategies to conserve these areas, and obtaining community input to inform each of these steps. The committee is advisory to the select board, and their process, plan, and definition of open space must be approved by the select board and then submitted to the voters for approval. So that's the proposed charge. It's not clear to me right now whether the open space plan would be an amendment to the comprehensive plan, that it would go to the state and the voters that way, or whether it would be like a freestanding plan that we submitted to the voters. But this definition leaves that open for us to figure that out later. So
Aren't open space plans, don't they typically have a lifespan longer than 10 years?
Would be the goal.
Yeah, so.
yeah, so it may be that for that reason, it would be a freestanding separate
And
plan.
then you also would need to get state approval for it.
Well, I don't know. I haven't,
Yeah, from the other ones I've read, I didn't get
It
an
didn't seem-
indication that it needed state approval. You can look at it.
Accountable.
Into that.
yeah, so did people have any changes or issues with the proposed charge? You want me to?
I just hope we get recreation in there. Is it mentioned at all? Recreational, or maybe it doesn't.
No, it doesn't characterize the kinds of property that we would.
I guess we understand that that's obviously a form of open space.
Yeah, I mean, that would be defined when the committee decides on the definition.
Sure. I mean,
But every town open space plan we looked at, slightly different, has some main common items in it, but then they each vary a little bit in terms of what they include or exclude.
and it sort of overlaps too, because most land is a beach is recreational, a trail, a playing field, they're all recreational.
You want to make a motion?
Sure, I move we approve the charge, the proposed charge for the open space committee.
Second.
Any other discussion? All in favor? That's all five. Judy, I'm gonna send this down to you so you can. Include. Thank you, Dale.
Hi, Dale.
All right, and I really wanted to thank Brandon and the staff for the extraordinary job that they did last Monday night at our special select board meeting. You know, we had about 200 people on the property between the big room and this room. There were people outside listening through open windows. There were over 50 people on Zoom, all the cars, all the people, and yet Brandon's team made that go so smoothly. And it really helps set a tone that enabled the community to get through a tough meeting. So thank you for that. And please let everybody know we feel that way. Our next meeting on December 1st, we will be having the person who handles our investments at the First Bank come talk to us, which they did last December, and also Wendy and Susie Ellis and others from the budget committee have been through the trust documents for monies we hold in trust for specific purposes for the town. And they'll share their, they'll make a report about that. So Brandon, your report.
I don't have much. The bulk of my time is being consumed by the things that have been showing up on agendas lately. So there's not much off of that. Ken and I have had conversations about different conservation commission projects going on, and sure he'll cover those in the report. We're struggling to find a way to access the back part of the Walston Road property that we got from Youth and Scouting. Is there an update from the water district? Will access be allowed?
I don't know. We have never been asked formally about access to that property. No, I mean, you've talked to me about potential trails.
Right.
But
right.
you've never asked me about any access to the scouting property.
Sorry, I only meant via walking trails, like via trails.
And all we ever talked about was, would we have access across the Pensacola Water District property to get from Oldwood Farm to the scouting property along the back border there.
To connect those two.
You mean through a separate trail other than the one behind Rosemary and Carol's house? Because there's that little portion that goes.
So where we would go off from Oldwood Farm, right at the beginning practically, right? Just before you even go across the brook. Then there's a little piece on Rosemary's property, right?
Right, there's a small water district property that's involved on that particular trail. There's like a little.
Oh, there's that little, there's that little piece over there, but what we're talking about is the trail that we've been trying to get to connecting Oldwood Farm to the scouting property, right? And that's.
Okay, so in addition to a recreational trail, it would be a way to access that particular property off Walston?
Right.
Okay,
right.
No, we have not considered that, and in general, we are probably enlisting a firm to look at our entire property. And I mean, I will bring that to their attention, but we're protective of the wellheads, and the wellheads are kind of right behind there. And especially in light of the comprehensive plan that we may be looking at drilling another well at some point in time, we're trying to keep all our options open in terms of where we would place another well. So
just to clarify, this isn't in addition to a recreational trail. This is
no, I understand. It's the same trail. No, I understand.
Gotcha.
But there may be a different stripe to that kind of trail.
Would it be helpful if you presented the water district board with a schematic that showed what it is that you would like them to provide?
Yeah, but I don't have the map with me.
Well, no, I'm not talking right now.
No, but we did have it charted already of what we were hoping to find in terms of it almost follows the brook all along the back of the water company property there.
Well, I mean, I think it would be helpful if you had a schematic, a newly drawn schematic that I can present to the engineers, because in general, they're not that excited about having people on the property because we're protecting water quality and there's safety issues about the wellheads. So, you can present it to me. We will talk about it not only among the trustees, but among the engineers. Okay?
But I mean, a while back, we thought the engineers would be out there and we'd walk it together at one point in time.
Well, I mean, we did walk it a long time ago, and the engineers separately walk it once a year, but I don't think there's been any particular plan. I gave you permission that you guys could walk it.
Right. And that's what,
Yeah.
for us to explore and see what was feasible,
Okay.
right?
Mm.
And we think it's feasible.
Mm.
So that's the question is, we haven't proceeded anything further until we thought we needed some sort of approval from the water district to go ahead and put a trail in there.
Mm. There's no other way from Walston? There's no other way
You can
to
get onto
access the
front
property?
half of the property.
Yeah.
You can't get to the back half, which is the bulk of the property.
Mm. Mm. Okay, well, if you present me with something, I'll talk to the engineers about it.
Okay.
I didn't have anything else.
Okay. In the interest of time, let's take these a little bit out of order and talk about the Josiah's letter that he sent in an email to all of us. I know, Brandon, that you had said that the Harbor Committee, after the floats came out, would take the opportunity to revisit, lessons learned and policy decisions about the Port Clyde landing facility and how it's working. It seemed to me like it makes sense for the Harbor Committee to schedule a meeting and take up the things that Josiah raised in his email and any other issues you all have become aware of since we opened that in June. Was it June? Does that make sense?
Yeah.
So if, Brian, if you wanna let Dave Szymanska know that it's time to schedule a meeting, and make sure that he has Josiah's email, and Ryan will be here by December 1st. He'll be back and everybody will be ready to address those things. The planning board.
The planning board has not met. It's, the next meeting is next Tuesday of Thanksgiving.
All right, the Board of Appeals has not met. That group needs two alternates, and I talked to Steve Miller, but I'm waiting to hear back. So, we do have someone who's interested, and I hope by the next select board meeting, I'll be bringing a name to you for that. The budget committee will be here next time. Cemetery committee we've heard from. Emergency services, there is that group is working on revitalizing the warming shelter group and bringing that into the fold of the emergency services responsibilities. They are also planning to begin some posts in the town newsletter and on the website that are educational about the community paramedicine program. And Katie, Jacob, and Dr. Lowry and Mike Felton met, I think, last week to talk about the telehealth hub, what that might look like, and what the town's capacity is to be involved in that. And I've invited them to come to the select board as soon as they have something specific to let us know what's going on with that. But there was another thing that arose that I just want to run by you all. I talked to Brandon about this. They raised the issue of fundraising and people wanting to make donations, say for a new ambulance or toward the community paramedicine program or toward a fire truck or something. And, we do now have the capability to put on our website, you can make a donation for the Snows Point Lodge, for example. And then if somebody makes a specific donation like that, then Irene opens a reserve account and puts the money, like for St. George Days, in a special place. And so Brandon and I talked about whether the select board felt that it was reasonable to have a place on the website that people could clearly donate money for a particular purpose. Now, like we have the tennis court fund, there, it isn't on there that if somebody else wanted to donate money that would go into that account, they could, but it seems like it might be worth making this possible.
Wouldn't it be more appropriate for the select board to weigh in on like a concentrated fundraising effort for these rather than what should be on the website?
Well, if we were interested in doing fundraisers, I mean, like we did want to do fundraising for Snows Point Lodge, so we already have agreed we're targeting that. The issue that kind of arose spontaneously at the Emergency Services Committee was, what if somebody wants to donate out of gratitude to the community paramedicine program? How would they do that? Or if somebody wanted to give money toward an ambulance, and I know once in a while people do that. So it really wasn't like we're gonna go out and fundraise for an ambulance or community paramedicine. It's more like, do we want to make it possible for people, tell people we're willing to accept donations for things like this, or even the cemetery, you know?
It just feels like the conversation that we had already about like putting donation QR codes up at tennis courts and public landings. And I thought what we had agreed upon was that when there were fundraising efforts taking place, like Snows Point Lodge currently, that then we would try to make visible ways to donate rather than asking to donate to every like department and service in town.
I mean, I guess I feel like it's different if it's passive and you just make it clear to people that if they want to do this, we're not asking them to do it. We're just letting them know that if they want to, here's how you could do it.
Older people don't use QR codes.
Right.
We're very suspicious of them. I'm just saying. I immediately think like fraud, flip flam.
To be clear, I didn't.
Yeah, I don't. The only thing that my only comment about this whole discussion is people continue not to understand that the ambulance and the fire department are under the town's umbrella now. And people are continually say to me like, oh, they're volunteer and they're not, they're this nonprofit. And I'm always trying to clarify that. And I guess in general about these things, not that it should make a difference. If you want to give money, you want to give money. But people don't understand that these are town departments now with big budgets. So that's my only observation. I mean, people can give money, I guess. I mean, how do they do it now? They write checks and write on the memo line.
And they pay their property taxes.
Right.
Right.
Mostly,
Is that what they do?
Sure, most of us, like the five of us, know that our property taxes are supporting these things.
Right, but I'm saying that if somebody wants to come in and give a donation for a new ambulance, what happens right now? What happens?
If they came in with a check, I would give
Okay.
it to Irene.
Uh-huh.
She would put it in the ambulance reserve account.
Okay.
Right.
But to me, like, I don't think that we would ever consider putting up a page on the website to donate to the transfer station.
Or Parks and Rec, or,
Just in general.
right, I mean, if you do it for one department.
I would do,
Then you gotta do it for
I would
every
do it for all of them.
And that's what I don't want to do.
You don't want to do that.
I think, Brandon, you made a good point, like, if we're in the middle of a campaign, then it makes sense. If we launch a campaign to do something, then make it easy, yeah. then people would understand that. Oh, yeah, I saw that you're campaigning for this.
I mean, if the emergency services wanted to, couldn't they put it out there that, hey, if you wanted to donate, we could use equipment, you can donate to the town, they'll put it in reserve.
Well, it would be we who would decide that, just like we decided that we would have a campaign for Snow
Well, that's what I
Point
mean,
Lodge.
couldn't we give them permission to do that instead of us putting it on the website and they could just say, go anytime.
Well, and I can take it back to them and ask them if, that was, I mean,
Well-
you were there too.
Is the
You
problem
know.
the website itself? Is that where the problem lies in this whole concept?
Two, one is that I always have a hard time with how much time we spend talking about what should be on the website.
Okay.
Based on the way that the policy
Okay.
spells out and how the website is
Alright.
administered.
Okay,
But secondly, I think it's a philosophical piece of sending people their property tax bills every year. You know, the EMS department is $1 million department.
right,
That is funded by
Right.
property taxes. And then so to ask for donations on top of it.
Right.
Is,
I think if people want to make a donation, they will.
up to them.
Okay.
and we can accept donations for anything at any point, but to ask for it, I philosophically just don't like. Snows Point Lodge is really different. We were presented with an opportunity to take on this building. We said, yeah, we'll do it, and we want to do it in a way that's responsible to taxpayers, so we're gonna try to fundraise some of those.
Next month.
Right.
I tend to agree.
All right, well then, we can take that back to them, and if the Emergency Services Committee wants to make a recommendation, at some point they want to have a fundraiser or something, that they should bring that to us.
And I do think Wendy's notion should be shared with them that, you know, I would never want to mislead and reinforce this
Right,
idea that they need
They're
donations
still-
because they're a non, you know, they're
Right.
separate nonprofit.
That happens, like, I would say in my conversations, 80% of the time.
Right.
That
people
people do
still
not,
don't realize.
they do not, yes, know that they are town departments.
They need to be looking.
Well, I know you could say that, but people don't, people don't know.
It's in
Yeah.
here, at the
I think
beginning,
it's just
you know.
because it's been
Their
so many
eyes
years
closed.
that it's been
Right.
nonprofit.
Right,
They
it's
send
true.
out requests for donations every year.
Well, and because people do know that the lobster stew, you know, there is still the volunteer
Right.
fire association.
Right.
The other thing that the Emergency Services Committee is working on is that Brian and Ryan are gonna be working on updating the emergency management plan.
Yeah.
Um. So it's almost 8 o'clock. Conservation Commission.
Okay, we had our meeting on November 6th. So I'm trying to hit the highlights. I attended the Maine Association of Conservation Commission meeting last month. And I guess the key thing that came out, they had a discussion about the Maine Trails Bond. Doug Beck, who administers that whole program for the state, was there and described it. The first round was oversubscribed by over 2 to 1. In terms of, they had $7.5 million to give out, and they had close to $16 million of requests.
Wow.
So they're deciding this month what to fund. But they encourage people to still submit submissions for the next round. Because not everything fits into one of the categories, but they have 3 categories. They have walking trails, motorized ones, and multi-use trails. Multi-use gets 50% of the money, the other 2 each get 25% of the money every round. So, you know, we don't know where all the submissions were the first round, but. And what we did find out though, is, you know, it's a 90-10, so they give 90% and 10% match is what's required to get 90% of the money. It does include acquisition money, so if we had a piece of property to acquire, we could apply for it through that grant. And it also would pay for an easement is a possibility. So if we in the future had something that we wanted to have an easement to access something, we could pay for an easement as well out of those funds. Guess on Oldwood's Farm, the survey was recorded last week, and I recorded the clarifying easement today. So we're making progress, and LMF has a tentative date for a closing of December 10th. So good chance we'll get our funds before the end of the year at this point.
Just on that note, Ken, it is officially open now, is that correct?
Yeah,
Or
I mean,
not quite.
since we had signed the clarifying easement, which, you know, gave the town permission for access, formal access. And we're gonna put a note, we're putting it into it's on the webpage already, and it'll be in the December newsletter.
Terrific. Yeah.
And you said you didn't really want to have a big open house because of limited parking there.
Right.
You're just gonna
No,
let
you can't.
people know.
Yeah, we'll just have that in the newsletter and have it on the website, so it'll be there.
Well, that's a very big accomplishment.
Yeah,
It's
it's-
been a long time.
Yeah, it was quite a
So,
struggle just to
it was.
acquiring the property.
There should be, champagne opened by somebody there.
We were talking earlier about in trails, we were talking about the scouting property earlier, when we were talking about crossing the water district to get there. We did go out again recently and look to see if there's any way to get from the front section to the back section. And we'd take 150 foot boardwalk to get across the wetland section probably, and whether we could ever get some grant money to do something like that. Possibility in the future. I did talk to Josh McPhail, how the scouts use the back property, and he said only in the winter. Right. So whenever it's frozen, they would get out there.
Yeah.
The other thing on the Meadowbrook property, we had to update and provide an update to the Meadowbrook management plan this last month. And we had submitted that. We had a meeting with the representatives that represent the Maine Natural Resource, not Maine, MNRCP, Maine Natural Resource Conservation Program, who funded the purchase of the Meadowbrook property. And they approved the submission of that plan, so we're good for another 10 years before we have to submit another update to the plan.
So there's something for the future's file.
And let's see. I guess the other thing we did look at and had someone come out in terms of the ash trees at Fort Point. The ash tree is the predominant tree on the Fort Point property. And if we don't do something out there, we're not gonna have any trees out there. It's unfortunate. So we had a fellow came out and we marked probably 40 trees with him. He's got to come back one more time in terms of doing the inoculation of the trees, which lasts 2 to 3 years. Would have to be repeated every few years. So we're gonna look into a proposal for doing something like that for the ones that are closest to the trail, and not worry about ones that if they fall over in the future, they're not gonna fall in a trail and we won't worry about them. So, something we'll probably be putting in for next year's budget to look at that and see how it works out. We may look at the last 3 years, we'll do a third, and a third, then we'll have some sort of program going forward on that.
Does the inoculation prevent the borer from creating harm, or what does the inoculation do?
It keeps the borer from creating, harming the tree.
Okay.
And actually, Stu Rich, with a number of the school kids, is going out and flagging the trees. So there's a little program educational program for a number of the kids from the school to learn more about it at the same time.
That's great.
Yeah.
I think that covers about everything.
Thanks, Ken.
Shellfish Committee.
They meet tomorrow at 5:30 in Warren.
Solid Waste is meeting.
They meet tomorrow at 2:00 here up in the big room. And I will not be able to attend because I will still be working in Rockport.
All right.
And I let them know about that.
All right. I'll see if I can go. I don't remember the schedule.
They could have Tara send out a report from the
Okay.
meeting.
Parks and Rec.
They did meet November 6th. Other than the 3, 4 girls issue, they talked about the rest of the basketball teams. They do have 5th, 6th boys and girls and 3, 4 boys. They approved coaches, which I think are approved. First, second grade clinics are gonna start in January. Weekends are gonna try to do Friday after school, because they did that last year and I guess it worked out really well, so. They set date for the Muscle Ridge basketball tournament. They're gonna do it March 6th, 7th, and 8th, which is a week later than last year, but 2 weeks earlier than they used to do it, so they're trying to find that sweet spot. And senior updates, they're trying to come up with some more stuff for seniors. That's Ashley's, one of Ashley's big goals. I think in December, she's gonna have their first senior social. I think, right, Brandon? Which is just gonna be free time to hang out and drink coffee and just socialize. And then,
Tomorrow, some students from the 3K and pre-K,
is that the luncheon?
yeah, are coming down to the luncheon.
Oh,
So,
cool.
Yeah.
Yeah, no, they love it when the school kids come. So
I'm sure.
they're talking about maybe busing them to craft fairs or something like this. So if anybody has great ideas for a senior program, Ashley's more than, she's really looking into it. She wants to do that. They talked about committee goals, but I'm not sure they set them. There's 6 of them, so I don't know if it's reasonable, but the Collins Park Court, which is already done, so I guess that one's done. They
I think they were gonna replace the hoops though,
Are they? I didn't know for sure what they were doing.
I believe so.
The rec center research is always a goal. They always want to look into that, so.
What do you mean by that?
They're researching, every year they put it on a goal because they don't want to give up on maybe having a rec center down here eventually, so.
Bigger rec center
Oh, yeah.
than Snow's Point
Yeah,
Lodge.
Rec center, yeah.
Like with basketball court and a pool. And
Yeah, I mean, 5 or 6 years ago, we got pretty deep into it for a little bit and then. I don't know, faded away. Maybe COVID, I don't know. I'll blame COVID. They talk about the Snows Point Lodge. They want to start working on trying to find people and help bring in and find people to get the work done. They're talking potential scholarships for rec camps and getting rec accounts set up so they can help kids get to camps that can't necessarily afford it, or maybe they can, they just need it. And they're looking to partner with other schools and outreach to high schools to get players, coaches to come down and work with our kids and maybe help them step up into a high school program and show them what they need to be doing. And that was it.
All right. Resilience.
Okay, you wanna do this? Or do you wanna? Oh, all
Do-
right, I have a lot, so.
Well, then we should make a motion to continue. It's past 8 o'clock. I'll move, we continue to hear from the Resilience Committee.
Second.
All in favor? All right.
Okay, so as you know, the Resilience Committee is working on 2 tracks. So there's many meetings every month covering both the joint grant with South Thomaston, which is the Climate Action Plan, which is now called something else, but that's its topic. And then also separately, there's the money going towards the cold storage and Factory Road project. So if I take them in chronological order, on November 5th, we met with South Thomaston to go over data and vulnerability information, and Letitia Van Buren presented us with the GIS viewer, which was really neat because we could give her an address and this is an expanded version of, I think, what Richard Bates started years ago. But for example, I could see my property at 2100 with a hurricane and a high astronomical tide, and all that was left, it was one corner of my property, which was scary. I mean, I'll be dead anyway, but it's fine. But it's really, and people yelled out their addresses both in South Thomaston and in St. George, and it was very interesting. So overlaid on the computer program, we saw FEMA flood zones, we saw sea level scenarios, we saw sea, lake, and overland surges, which the acronym for that is called SLOSH. And so we looked at different things to look at two things: safety and whether it was a community asset. So as a result of that meeting, I think that joint committee is going to break down into two action vulnerability teams, one for each town. But we have to be careful because there's going to be one report at the end, and it's going to be a joint look at both the towns. But in general, things about culverts and access and waterfronts is going to be refined by these vulnerability teams. So that is the South Thomaston St. George side of things. Okay, separately on November 13th, there was a cold storage and factory road Zoom resilience meeting, which was designed to focus on all the homeowners that abut both of the roads. So it was a kickoff meeting, and we talked to the homeowners about such things as whether they would ever be interested in closing either of the roads. And there was pushback on that, and not every homeowner was on the Zoom meeting, but there was a couple of them on there. And there was also people who joined who complained that they weren't notified by the town, but they were not true abutters to the roads. So I don't know if you had any pushback, but for all these meetings, people complain about access and not having notice. But in general, I think the town and the staff and everyone has done a really good job of identifying people who should attend these meetings. I think there were phone numbers and postcards sent out. So that did become an issue.
They did ask for emails, and we just don't collect emails.
Yeah,
So we
yeah.
had to share.
Yeah. And
mailing addresses.
don't they have a consultant that's supposed to be providing the notice? It's not really the town.
Well,
They're supposed to provide the notice, I thought.
Right.
I don't
Once we
know.
have emails, I think they didn't know what to do.
Yeah, I think that's true.
Well, I provided as many emails as I just happened to have from different past communications with people in Port Clyde.
Mhm.
But I mean, they could obviously get addresses from Megan Wallace and,
Oh, we gave them addresses.
yeah, okay, well then,
Well,
that's
I
the
think,
problem.
yeah, I think things were sent out. I don't know, but just know that there was, a little furor during the meeting about people weren't notified. So, I mean, that happens every time, no matter what we do, no matter if we use semaphore or smoke signals or people always complain. So
I was frustrated as well, though, because we were paying a consultant for that, for the community engagement part of the project.
Right,
Not
right.
Sebago's doing the design, but then.
Right.
the community
Right, there's a
engagement piece.
separate subcontractor, but I have to say that she's really great at community engagement. Her name is Venus Scortis, and she's really positive. When people gave somewhat negative feedback about what we're doing, she turned it into something positive. I probably would have sat there with a sour look on my face, muttering my grandmother's Swedish curse, but she was really good about folding that into what they're doing in terms of community engagement. Now, one thing came up is several residents want a traffic study. And the consultant said there's really not enough traffic to make a study worthwhile, but that became a recurring theme. And I'm not sure, a traffic study is a particular animal where they have counters and they look at rush hour and really what people were saying is, how do residents use the roads? But how do tourists use the roads? And we have to acknowledge that tourism is part of our economy, and how do we address that need? So, and the other thing that comes up in all these meetings is talking about funding. And the problem is that for all these topics and grants, people want interim solutions. And we don't have the money. We don't have the money for any of it yet to make the actual construction. But we don't have the money to take steps, say to bolster infrastructure before a storm. We don't have the money to do that. I mean, in general, once infrastructure is washed out, we figure out how to do a patch so people can drive on roads, and then there might be a longer term solution. And we're going to have to find funding for all of these things, because in many cases, they might be over $1 million, and we just don't have the money built in our budget. So in general, I just think we need to tell people that we may be able to do these projects, but there's not going to be major fixes along the way until we have the ultimate engineering study that tells us what we need to do to address the underlying issue. So that was the November 13th Zoom meeting. This Thursday on November 20th, there is another meeting here, not just for the abutters. And I don't know, I'm not sure if I've seen any publicity about it.
It's on the website.
Okay, okay,
Post.
great. Okay,
Bill
good.
Daddy sent out an email on it.
Oh, good,
We're on the
good.
distribution list.
Good. So that is for anybody, anybody from the entire town to come and talk about their issues with these two roads, what they see as the long-term future of the roads. So anyway, that is the cold storage and factory road next meeting, which is again this Thursday here. I think it's at 4:30. So that's all right. So
All right.
that's it.
All right. Well, I think that brings us to the end of the meeting. All right, Steve moves that we adjourned. I'll second that. All in favor?
That was a very
And there are probably
a lot of